Hi, welcome back. Welcome to Diary of the Law, and I'm so glad to be here. I genuinely love being here so much. Hi, guys. To our old and our new subscribers, welcome. This is Diary of the Law. Today, we're going to be discussing stealing. So, yeah, stealing. That's what we're talking about today. So, stealing is one of the most popular crimes, and we're always saying it, oh, you stole my cup, oh, you stole my friend, you did this, you did that, right? So I'm going to actually explain to you what stealing is from a legal perspective, so that next time that you tell someone that they stole something from you, you would know what you are talking about, and they will also know the gravity of what they are alleged to have done. So yeah, let's go. So stealing is provided for in section 383 sub 1 of the criminal code, which is applicable in the southern states. That is where the offense of stealing is basically provided for in the criminal code. Section 383 sub 1 of the criminal code provides that a person who fraudulently takes anything capable of being stolen or fraudulently converts to his own use or use of another person that which is capable of being stolen is said to have stolen that thing. Let's talk about that in bits and sections. So first off, it says that a person who takes anything that is capable of being stolen, who fraudulently takes anything that is capable of being stolen. And so let's talk about what's capable of being stolen. What does that even mean? So anything that is movable is capable of being stolen. The things that are not movable, things like land, you cannot just uproot the land and take it somewhere else. That is not capable. So you cannot say somebody stole your land. So if you're saying that, stop it. That person did not steal your land. Do you understand? So anything that is capable of being moved, movable items, are things that are capable of being stolen. So still on the subject of movable and immovable property and what can be stolen and what cannot be stolen. Still on this land thing, right? There's a particular case I really like, and it's the case of Ojiko versus IGP. Let me tell you what happened in this case. So in this case, the accused was given some money to buy a land, and the plan was to buy the land and then transfer the title of the land to the owner, right? So he was supposed to be an agent in that sense. And then he buys the land. He actually makes use of the money for what's supposed to be used for. He buys the land. He actually buys the land, right? But he refuses to transfer title to the original owner, right? So the court now, was looking through this case. Oh, what do we do? What do we do? And then the court held that you cannot say that the man stole because he stole the money, because he used money what it intended to be used for. He said buy land and he bought the land, so he did not steal the money, right? Can you say that he stole the land? He didn't steal the land because land is immovable. You cannot steal land, right? And so in that particular case, it was fairly obvious that the crime of stealing could not be associated with the accused, right? But obviously justice was done, but just not as related to stealing as an offense. Yes. Another essential term in the definition is fraudulently taking. So someone can actually take your thing even with your consent, but if it's fraudulently done, then it will amount to stealing. So the other from clause in this particular definition, based on section 383(1), is that if a person fraudulently converts it to his use or use of another person, and so any act of conversion whatsoever will amount to stealing, whether it is for your own personal good or the good of someone else. And so if I took your pen, right, and I gave it to my friend, that is stealing, even though I'm not the one actively using it, because I was the one who fraudulently took it and gave it to someone else for someone else's use. I will still be responsible, or still be criminally liable for the offense of stealing. Do you understand? So a person who takes or converts a property for his own or another person's use whatsoever must do so by showing a certain level of intent. And the first thing that he must show is that he must show an intention to permanently deprive the person of the use of that particular thing. And so he must attempt to permanently deprive that person of the use of that thing. Do you understand? So if a person attempts to only deprive you temporarily of the use of a particular thing, then it is not stealing, right? But if perhaps the person takes your pen to just write a letter or just to sign a document and the person returns it back to you, that does not amount to stealing. It probably amount to trespass and tort, but then in criminal law it's not amount to stealing because the person only attempted to deprive you temporarily of that particular property. But there's a certain gray in this. The gray is that if a person attempts to deprive you of a particular thing permanently and then midway he changes his mind, let's say Holy Spirit enters him and then he says, I'm going to change my mind, that person is still responsible. How do you know for certain if a person has an intention to permanently deprive you of your use of that property? If somebody takes a car from your house and the person sells to somebody in Kano and you live in Lagos, Nigeria, that obviously demonstrates a clear intention to deprive you of that thing permanently. If somebody sells your property, or the person even permanently modifies it. You have a red car and then the person paints your car black. That's a clear show of an intention to deprive you. You understand? So yes, that's it. I've been talking for a bit, right? But before we even go any further, I have a question for you. Yes, you know what time it is. You know what time it is. It's what? Now the particular question is section 383, subsection 1 of the Criminal Code, applicable where? In the Southern States. Yeah, that's it. Great job, guys. Great job. So a person will also be regarded as having fraudulently taken the good if he shows an intention to use that particular good or property as security. You borrow from the bank, you take a loan from the bank, and you use another person's property to do collateral. That is stealing. Yeah. Also, there's also the intention to use the property in a way that will substantially, please note the word substantially, change the good, change the property. And I remember this in passing. Somebody takes your red car and paints it black. That means that substantially altered the property, and so by doing that, it showed an intention to fraudulently take it, to fraudulently take possession of that particular property and to steal. So yes, the last intention that we need to examine, that is when it relates to money. If a person gives you some money for a particular purpose and they use the money for another purpose, even when you have an intention to repay the money back, it still amounts to stealing. So in the case of R versus Orizu, the man collected money from some students to take them to America for a scholarship. But then America did not go. The money they did not collect. And so that whole interaction amounted to stealing. Because even though you had a plan to return the money, they gave you the money for scholarship and you used the money for something else. That is stealing, right? I also want to put this out there, right? If a particular person gives you some money to let's say buy let's say a chair. I'm sitting on a chair right now. I'm not sure if you can see, but I'm sitting on a chair, right? And the chair costs 20,000. The person gave you 30,000 naira. If you keep the 10,000 naira left, you have committed the crime of stealing. Because by keeping the 10,000 naira, you have misappropriated the funds. You ought to return the money. Yes, I know that in this day and age, it's not something that's very common, but it's very important as people who are actively trying to stay legal and stay safe to always return what we do not use. So yes. Another case is the case of State versus Odimayo. So in this case, right, the man collected a loan to build a house, and then he used the money to contest an election. And then the court held that even though I believe that his plan was to win the elections and then take the money back from the public funds, but he didn't win anyways. But that's not the point. The point is that by doing that, by using the money meant to build a house which he loaned from a building corporation, he had committed the crime of stealing, and then the court held that he was guilty of the crime of stealing. So I've spoken a lot about stealing. Perhaps I've accused you of stealing. I'm sorry if you're offended. Please do better. We have spoken a lot about stealing. So what is the punishment for stealing? Right? Under section 390 of the Criminal Code, the punishment for stealing in the southern states is 3 years imprisonment. Yes, you'll be in prison for 3 years. 3 years of your life. That's about. Alright guys, that's it for today. Don't forget to like, to comment, to subscribe, to share, to do the whole works. And again and again and again, I'm really grateful for you being here. It means a lot. Thank you for all the comments and the likes and watching the videos. Some people have watched them multiple times. Thank you so much, and thank you. If you have any questions, please go ahead and attend to them. It's my joy. It's my joy to attend to your questions. It's my joy to be here. So yes, thank you so much, and I'll see you in the next video.